A very good morning to you and welcome to today's webinar, The Essentials of Estate Planning and Elder Law, presented by Elville & Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. And if you're returning, welcome back. So you as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout to address them. As always, your questions really help the presentation and add value. They help others learn, so please don't be shy in posing your questions at any time. You received the presentation yesterday by email for me to take notes on it if you wish. If for some reason you didn't receive the presentation yesterday, it is currently in the section marked handouts in the panel on your screen to download at this time. For our professionals on today's webinar, CFPs, CPAs, and various others, you may receive 1.5 continuing education hours for attending today's webinar. So per my attendance records requirements, please email me your ID number if I don't have it already. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval, which I'd like to do by tomorrow afternoon. Everyone will also receive a post-webinar feedback email right after the presentation, and we do ask that you please just take a couple minutes to fill out this survey to offer us your feedback about the presentation, and we read and value every comment. It's also an ideal time to request a consultation from Steve for planning needs that your family and you may have. And here at Elville & Associates, we look forward to being a resource to you now and in the future. So briefly, I'd like to offer you an overview about our firm and share a little bit about Steve for just a minute or two. So you should be able to see my screen here. So Elville & Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at our firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, which works very closely with the rest of our practice areas, tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Steve and I are coming to you live from the Columbia Gateway community location right now. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at Elville & Associates, as you've come to know. And we do that in a number of ways through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities we serve each year. And also by way of our accredited client care program, or CCP as we call it here, we are one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work every day with the ideals of client education, collaboration, and compassion in mind with every client, every time. A little bit about Steve. His work as an attorney for the past 20 plus years, 22 to be exact, has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, the National Network of Estate Planning Attorneys, works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve speak, presenting at many, many presentations, workshops for businesses and their employees, conferences, continuing education events each year. Also named to the Maryland Super Lawyers list for a 7th time in 2022, so congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I am privileged, as always, to be the executive director of. If you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me and I'll be happy to share our story with you. So with all that said, we're going to go ahead and get started. We have a brief poll that I'd like to go ahead and share with you just to get to know our audience a little bit. It's always helpful to Steve and see what brought you to our webinar today. And the poll simply is, what brings you to today's webinar? And your choices are: 1, I am new to estate planning and need to get started. 2, I have a plan in place, but it is outdated and needs updating. 3, I feel my plan is on solid ground, but education is always great. Or 4, I'm an advisor here to learn to better serve my clients, which is always great too. So welcome to our clients. If you're new to Elville and Associates and checking us out, and to our financial advisors that are here with us today. So it looks like the choices are coming in fast and furious. We'll give it a few more seconds. And with about 85% of those having cast their choices, we have 33% saying I'm new to estate planning and need to get started. 19% say I have a plan in place, but it is outdated and needs updating, which is not out of the ordinary. 18% say I feel my plan is on solid ground, but education is great. Yes, it is. And 32% say I'm an advisor here to learn to better serve my clients. So welcome everybody. Steve, I'll go ahead and turn the presenter rights over to you.
All right, Jeff,
There we
I
go.
think I have the screen, and hopefully you can let me know if my screen is now being seen.
It is. Looks
All right,
good.
thank you so much, Jeff, and good morning,
Right.
everyone. Thank you so much for that introduction, Jeff. I'm very excited to be with everyone this morning. Thank you for taking your time, your very valuable time, on this Wednesday morning. I'm Steve Elville, and I'm not only privileged to be the lead attorney and principal of Elville and Associates and to lead our law firm, but I'm also very privileged to be with you this morning. And is it really the end of the month? I can't believe it's March 30th. Spring is in the air, although the cold is hanging on just a tiny bit more, but we will get to spring for sure. And a lot is going on in the world, a lot going on in your lives here in the middle of tax season and other things as we lead into spring. So today we're going to begin on time, we're going to end on time. My job is to lead you through a discussion, to teach you, to give you what I would possibly call a mini master class on the subject of estate planning and elder law, so that you have some substantive tools that you can use after today. You could actually refer to this presentation and have something substantive from which to refer to and to act on. And that is my goal. I also want to facilitate a path forward. Once a financial advisor said to me, Steve, you do a great job of teaching and leading, but we also want to help clients facilitate a path forward to have documents reviewed, to have questions answered, to have meetings face-to-face. I'm sitting here in Elville and Associates conference room number 1. We're very blessed to have a facility with all the latest technology. We are here to have those kinds of discussions and to facilitate a path forward to implement solutions for you. I want to thank my longtime friend and associate, Jeff Stauffer, who will moderate today's discussion. Jeff is an expert. If you've never been on one of our webinars before, please let us know what your questions are. We will take occasional breaks in the discussion to actually answer questions, and we will have a question and answer at the end. So with that said, thank you for spending your time with us this morning. We're going to get started. So today we're talking about what estate planning is and what it is not, but we're also going to be talking about a process. Estate planning is the best when it actually is part of a bigger process. And without process, estate planning can many times work in ways we didn't anticipate. In other words, estate planning can actually not work the way we want. Estate planning can actually fail. It can fail to do or fail to accomplish what our goals are. We're going to talk about wills versus trusts. We're going to talk about probate versus non-probate concepts. We're going to talk about elder law, taxation, and asset protection. These are very broad topics, but at least we're going to touch on the basics of those today. And as I mentioned, we're going to talk about taking next steps and how to move forward in today's world with estate planning, review of documents, and so forth. So we want to understand process. Process is so important in estate planning, as it is in many things. And we need to understand what our goals are. And again, we always want to not focus on this, but we want to keep it in the back of our minds that if we have goals, which we must have for good estate planning, those goals need to stay on track, not just now, not just at the time we're thinking about doing planning, but throughout the years to come, because we want to avoid an estate plan that actually could fail due to inattention, a failure of maintenance and updating, and we're going to talk about that in just a second. So we want to be driven by a purpose, driven by a goal. I'm going to give you some examples of those goals this morning. If you think about this, anything that you've probably ever accomplished in your life, you probably had a goal, you went toward that goal, and you probably had a purpose. So many people are not aware of this. But when you think about it, all planning, whether it's tax planning or financial planning or special needs planning or charitable planning, all types of planning has to be in one way or another goal driven. So we want to have a purpose. We want to be focused. We never want to get off of that focus. Many people use these types of things as their goal, or see these types of things as their goal. Providing certainty, providing smooth administration. Many people will say, I want to simplify the administration of my estate. And that's going to be relevant to each individual person, what that means. We need to kind of flesh that out in discussions. Minimizing the cost of administration is something that's important to someone. Asset protection. We're living in a world today of uncertainty. Many people want to provide protection from remarriage and protection for spouses and protection for children and grandchildren. And again, many people are driven by tax minimization. How do I minimize taxes as part of my estate planning? Some of you have special purposes that you want to attain. You have a foundation, or you have a charitable other than a foundation, a charitable purpose otherwise, or you have a special needs child in the family. You have very unique concerns about a particular thing. So we want to help you, and you should be thinking about, how do I attain my particular goal in planning? Now, as I mentioned early on, because I think this is very healthy to think about, if we don't know what we're shooting for, if we don't know what our goal is, and if we don't maintain our plan throughout our lifetime, our actual estate plan can fail. It can actually fail to work the way we want, fail to accomplish the goal we were trying to achieve, and it is a bit of a mountain to climb. So I don't want to have any misconceptions about this. Good estate planning requires attention not just now, but attention in the future. So this process of attention, this process is what we want to focus on. We don't want to be the person, or have clients, if you're an advisor on this webinar, we don't want to have a client, or we don't want to be the person who fails to do these follow-up items. And every 19 or 20 years or so, we actually update our planning. So we don't want to do that. We want to put a plan in place, and I'm going to describe the process a little bit more here. I would say there are two types of estate planning. There is the traditional notion of planning, which is document driven. I had a person come in the other day, very nice person, who was focused on documents. That person said, well, what's going to happen to my document? And look at this document I brought in. And you know, how much does it cost to get a new document? They were very document driven. And I understand that because in essence, all we have in estate planning as far as something tangible is a set of documents. But I want to take you beyond that. I want to take you beyond that notion that estate planning is just a set of documents. That's the traditional notion. And the problem with the traditional notion of traditional estate planning is that when we focus on documents, we are automatically heading in the wrong direction, because a focus on documents is going to lead us to an environment in the future where we are not reviewing those documents. We are not learning. We are not in partnership with our advisory team about our estate planning. And it's going to take us in a different direction, as opposed to the second type of planning that I would just argue is what I would call a process-driven plan. A plan that's not just focused on documents, but is also focused on education, education of children, education about fundamental concepts like we're talking about today. And that is a very, very different thing. And it also has a focus on maintenance and updating. So I've already covered these bullet points, but I just want to show you that this information is here for your review. Traditional estate planning is the kind of planning that causes a plan to not work exactly the way we want it to. And that's because we just don't have the mindset in this type of planning for maintenance and updating and education. Now, as we start to avoid that process, we start to think about a broader process. This is the process of discovery. This is the process of really understanding what our goals are. This is the process of taking the time to think, to utilize our advisory team, to utilize our CPAs and our financial advisors and our insurance specialists and our estate planning attorneys to really think in broader terms about the future and to coalesce all of those things together. And that process, I would argue, is a three-step process, although the number of steps doesn't matter. The idea here is to design and discuss and understand what our goals are and implement that plan, and then to maintain that plan over our lifetime to keep pace with changes in the laws, the changing environment of our world, and to educate our beneficiaries and our fiduciaries. And then, if we've done those two things, then the final administration of our estate or trust is going to work the way we want. So this is how we control, this is how we have that process-driven educational process. So again, this is our basic notion that there are two types of estate planning. Now, that doesn't mean that if we have clients or a person who says, hey, I'm going to Europe in 7 days and I'm very worried and I need some documents in place before I go. Yes, that's very, very important, and the documents are important. But overall, we want to have a lifetime process of learning and teaching our fiduciaries and our beneficiaries. Now we have a plan that will work. Estate planning is about several things, but this basic definition is something that I want you to take as a basic premise, and I want you to think about it beyond these basic rules and this basic definition and formulate it into your own idea. So estate planning is about disposing or giving your property the way you want to the persons or organizations of your choice at the lowest possible cost. So estate planning arguably is about disposing or giving your property the way you want to the people or organizations of your choice at the lowest possible cost. I want you to take that definition and I want you to think about that after today. And I want you to think about, what are my goals in planning? What are my priorities? What are the things that keep me up at night? What are the things that worry me the most or that I have a concern about? Or is my concern really just to know that I have a solid plan from top to bottom and you don't have any particular worries or concerns? But again, a lot of those things can come out in a meeting to discuss what your goals and ideas are. Now let's get into the discussion of wills versus trusts. Then we're going to take a short pause to see if you have any questions. So probate versus non-probate is really the discussion of wills versus revocable living trusts. Wills versus revocable living trusts. This is one of the biggest questions in America about estate planning, and it's something that we're going to just define for you again right now so you can think about it. So a will is subject to probate. Probate is the process of public oversight. For example, I'm in Howard County, Maryland today, where I'm sitting. There is a register of wills for Howard County. The probate of an estate or a will would go through that register of wills for people in Howard County, or a person who dies in Howard County. So this is a process that takes about 9 months on average. On average, there are different types of estates. So I'm giving you very big generalizations today, just so we can get this concept down. So a will, by its very nature, is subject to probate, subject to the probate process. If someone dies with no will, but they have probate assets, those assets are going to be subject to the probate process. So the first thing we probably should ask ourselves is, what is a probate asset? A probate asset is an asset that has no beneficiary and no joint owner, no beneficiary, no joint owner, and it is in the sole name of a decedent, a person who died. So real quick question for you. If I die with an IRA and I have a beneficiary, is there probate? And the answer is no, as long as it's a beneficiary that meets the requirements of the Internal Revenue Service. If I have a life insurance policy and it has a beneficiary, does that go through probate? And the answer is no. If I died with an IRA and I had no beneficiary, would there be probate? And the answer is yes. And the worst part about that, for example, is that there would be an acceleration of taxes. So we want to make sure that we have our beneficiary designations correct so we can avoid probate. But the basic concept is that if I own a property in my own name, let's say it's a piece of real estate, and it's in my sole name with no joint owner, no beneficiary, then it's going to go through probate. Now, the average cost of probate, according to AARP magazine, across the United States is 4 to 7%. This is if we take into consideration the statutory fees that are allowed in probate. And many people get upset at me about throwing these numbers out, but they came from AARP, and the statutory fees in Maryland are roughly 4% for a regular estate. So that's where I'm getting these numbers from. Let's talk about what a will looks like. A will plan looks like this. We have the will as the driving force of the plan, but then we have the incapacity planning documents. We have powers of attorney for financial affairs, and we have advanced medical directives, and for many of you, a MOLST form, MOLST, for healthcare decision making in Maryland. But what we've done with this 3-part structure is we have what happens at death with the will. We also have what happens during life with the powers of attorney. And as long as we have agents for financial purposes, agents for health purposes, we have now avoided guardianship of our property and guardianship of our person. So that is a will-driven program to take care of what happens at death and to take care of what happens during life. Now, a revocable living trust is really a substitute for a will. So sometimes I say this is a fancy will, but that's really an inaccurate description. This is really not a will. This is a contract type of document. This is where a person can say, I choose to not have my estate go through the Register of Wills process. I want to create a private document. I want to avoid probate. So I have a trust-driven plan instead of a will-driven plan. And what happens here is we have two steps. We have to create the revocable living trust. And I'm just going to show you what that looks like very briefly, and we're going to come back. Here we see the trust is driving. It's the driving force of the planning. But that trust is only as good as its funding. So this trust has to be funded with non-retirement assets, real estates, mutual funds, stocks and bonds that are non-IRAs, cash, savings bonds, CDs. All of those types of assets go into a revocable living trust. Do IRAs go into a revocable trust? And the answer is no. IRAs are not retitled in a revocable trust. Now, once we do that, we have taken those 2 steps. Now we have an estate plan that's going to avoid probate. So the person who wants a revocable trust should be the person who wants to avoid probate while still maintaining control of how assets flow down to your loved ones and beneficiaries. Now, some people have a misconception about revocable trusts. They think that the revocable trust protects against something, but it does not. The revocable trust does not protect against creditors. It does not provide asset protection. It's a wonderful tool for incapacity planning. It's a wonderful tool, if it's properly done, to avoid probate, but it does not provide asset protection. And it does not provide any tax savings. So we need to understand that this is a probate avoidance device. It is a very baseline document. I want to avoid probate, so I'm willing to go through those 2 steps to control the assets as they go down the line. That's a revocable living trust versus a will where the person's goal is not, notice I said their goal is not to avoid probate. Their goal is simply to have a basic estate plan. So the cost of probate is avoided with a revocable trust that is properly done. And you'll notice that the typical cost of administration is probably lower overall. That's going to depend on the diligence during lifetime, the education and the updating and the maintenance of the revocable trust and the trust funding to make sure the assets are aligned with the trust. If we do all that properly, then we are going to have an estate plan that is easier to administer and it's going to be less expensive. So again, the revocable trust is the driving force of this plan. Notice that there is a backup will. I would say about once a month at least, I see a client that comes into our office and they have a trust that has never been funded. So we don't want that. We want to always understand that the trust has 2 steps. It has 2 steps. The first is implementation. The second is funding and alignment of the assets. And I would also argue maybe a 3rd step, and that is lifetime maintenance of the trust. Now notice we have powers of attorney and advance directives. So here we're doing the same thing. We have what happens during life with the powers of attorney and advance directives, and also what happens at death with the revocable trust. With one exception, and that is that the revocable trust also has a lifetime component. If it's properly funded and you become incapacitated, it functions as an incapacity planning tool to pay bills, take care of you during your lifetime, very similar to a financial power of attorney. Lastly, before we get to questions, let's understand non-probate funding outside of a revocable trust. Many of you are aware of these types of devices, I will call them. Simple things like joint ownership, beneficiary designations, life estate deeds, beneficiary designations such as transferable on death at a brokerage house, or payable on death at a bank, or an in trust for account, which is very similar to a TOD or POD account. So these particular devices can be used to avoid probate. The reason that most people do not use these except as specific tools is because you cannot ultimately control how things flow down in the event of changed circumstances. So we all many times act on the assumption that we know exactly what will happen in the future. We will die first, we will leave the younger generations our assets, and everything will flow accordingly. Well, unfortunately, many times this does not happen the way we envision. Life throws a lot of curveballs at us. So if we use these designations and we don't use wills or trusts to control the ultimate disposition and to deal with contingencies, what happens if this happens? And if this happens, then this contingent distribution will happen. Or if this person is disabled, then this is what happens. We don't have the flexibility about how assets ultimately flow down. So what we want to do is understand that these are powerful tools and we do use them, but we don't recommend using them as the total estate plan. These are devices to be used in conjunction with a will or trust from an estate planning point of view. Now, notice that you could have a great will or trust, but if you don't fund that plan, even with wills, I could argue that there are two steps. The first is the design and implementation of the will, but what do we have to do with wills? We have to make sure our beneficiary designations are correct. With trust, as I've mentioned, we have two steps as well. Design and implementation of the trust, plus the funding and alignment of assets. Here we have a wonderful will or trust, but look at how all the assets passed. The assets were beneficiary designated or jointly owned, and they passed to the beneficiary without regard to the documents. So they actually passed outside of the documents. And here we see a similar example. So if we, like most people, want to control and plan and dispose of our assets according to our goals, then we don't want to depend solely on these devices or these designations, because what can happen is they can flow outside of the alignment of our plan and defeat our purpose. So funding, or what we may call the alignment of assets, is the key to estate planning and elder law. Arguably, how you own your assets at the time of death is the most important of all considerations. So if we have a will, we want to own our assets a certain way. We want to designate our assets a certain way. If we have a trust and we're trying to accomplish a certain goal, we want the assets to be aligned and funded properly so that everything flows properly. Jeff, I'm going to take a break. We've been going for about 30 minutes, and I'll see if there's any questions.
Okay, Steve, thanks for checking. No questions yet. That's not unusual for this presentation. I'm sure they're coming though.
Thank you, Jeff. And I know it's a lot of information, so thank you for your attention. And these are very deep subjects. It's a lot to take in. So now we're going to enter into another subject, incapacity planning. So I'm going to try to simplify this for you. This is arguably the greatest issue of our time with the state of the world, COVID-19, the war in Ukraine, the unrest around the world, the whole situation in our lives these days with so much information and changing circumstances and the potential for illness and all of the things that we're dealing with and the worries that I know you have on your mind for yourselves and for the future and for your children. Arguably, financial powers of attorney are the most important of all the estate planning documents. Jonathan Blottmacher, who is regarded as one of the greatest or most well-known estate planners in the world, has said before that no matter what the level of wealth of a person or lack thereof, that a power of attorney is arguably the most important of all estate planning documents. So we want to take this subject rather seriously, financial decision-making, healthcare decision-making. So let's take a brief look at this. In Maryland, we have statutory powers of attorney. This has been the case for about 12 years. This new legislation cleaned up Maryland power of attorney laws, which were in desperate need of revision. 2010, the Maryland Power of Attorney Act came out. The Maryland Power of Attorney Act created two statutory forms. These forms have their place, they have their utility, but also advanced estate planners create durable powers of attorney, general powers of attorney to go along with these simple forms, excuse me. So powers of attorney are designed in an estate plan. My recommendation is that you have a healthy understanding of what powers of attorney do, how they can be designed, what are the ideas behind them, not only to take care of you and pay your bills, take care of any person who is dependent on you, and including taking care of a spouse, but also to understand the broader implications of a power of attorney for long-term care and other asset preservation concepts. Advanced medical directives, they provide a path to avoid guardianship of the person, whereas powers of attorney avoid guardianship of the property. And some people consider the Advanced Medical Directive to be the most important of all documents. So these are unquestionably extremely important, and Elville and Associates, to my knowledge, is one of the only law firms in Maryland that actually spends an entire meeting discussing these documents and the nuances and design of these documents. So avoidance of guardianship and creating a situation where your incapacity planning is customized is something that we know as estate planners and as elder law attorneys, that this is very, very important, and many times more important than the designs of wills and trusts at times. Now, the statutory power of attorney in Maryland is a scripted statutory form that's actually in the Code of Maryland. I'm not going to spend a lot of time on these slides and the next 3 or 4 or 5 slides, because these are strictly for your education to show you that a Maryland statutory power of attorney is either not enough power for most people who are doing estate planning, although it has its utility. It is enforceable by law in Maryland. You should never have a circumstance where you are using one of these forms or someone is using one of these forms for you and the form is not accepted. This must be accepted by law. So either the power in the form is either not enough, although the form has its utility, or the form is not flexible enough, because remember, this is a statutory form and we're not supposed to, as attorneys, change this form too much. So I'm just going to give you some examples of what the simple Maryland power of attorney does not cover and how it needs to be enhanced through the use of a customized general durable power of attorney. So what I hope you'll get out of those last several slides about powers of attorney, when you have a chance to read them, is that we want to design the power of attorney with your goals in mind. We want to keep in mind that it is a very, very powerful document to be implementing, and it has consequences, and you need to have a healthy awareness of the powers, your goals, and what the broader implications are of those powers of attorney. And is it something that you're happy with and feel good about? Otherwise, we should not implement it if it has too many powers that you are uncomfortable with. Medical decision making in Maryland. This is something that continues to evolve. We want you to customize your advanced medical directive. Most people don't realize that the advanced medical directive can be customized. We strongly recommend that you do customize this and that you take the time to do this with your preferences, your thoughts, your ideas, your goals, your values, because when you think about it, your loved ones, your agents, the only thing they will know about your healthcare preferences is what you say in this document or what you've told them verbally during your lifetime. So we want to consider all of these things, including flexibility. How much flexibility do we want to give our agent? In some people's eyes, nothing could be more important than the advanced medical directive. The medical order for life-sustaining treatment is something that is required in Maryland. It is a medical order. We at Elville and Associates are not physicians, but we strongly recommend that you consult with your physician. 3 weeks ago, we had an aging life care manager who is very well known, Jill Rossner, who attended one of our client events and gave a discussion about MOLST that I had been awaiting for many years and hoping that she would do that discussion, and she did. She brought that discussion, and in that discussion, she brought to our attention that her recommendation, unlike what we are taught in Maryland as lawyers, she recommended that all clients who are aging have a MOLST form, MOLST, the medical order for life-sustaining treatment, versus the idea that we were always taught since 2013 that MOLST is something that's required when we are in a facility, or if we have a chronic illness, we should have one, but otherwise that our healthy clients who are in their 50s or 60s or 70s don't need one. But now we have a different perspective that if you are aging, like all of us are, that you should have a MOLST form, according to Jill Rossner, during your lifetime, and not just when you live in a facility. So this is a piece of education for you, for your healthcare agents, for your family members, and we're happy to get you in touch with Jill Rossner or other life care managers if you would like to discuss this further. Jeff, I'll stop again before we get ready to take the turn here into the tax environment and the current environment.
Thanks, Steve. No questions as of yet.
Very good. So people must be taking notes and having their third or fourth cup of coffee, or your first cup of coffee, whatever it may be, or tea. And I'm just now going to launch into the current estate planning environment. So we are still in a wonderful environment for estate planning. I say that having started years ago in the various environments of estate planning. We are living in a world where the federal estate tax exemption remains at over 12 million. 12 million per person can be exempted from estate tax. It's a wonderful situation, unprecedented. 12,060,000 per person roughly, over 24 million for a spousal unit. We are living in a wonderful environment where the tax proposals from 2021 were never implemented. Many of those onerous tax proposals about the loss of the cost basis adjustment of death, the loss of the step up in basis, the decrease in the exemption amounts, all of those things, plus many other things, such as getting rid of the advantages of grantor trusts, all of those things, plus more, never occurred. So these were things that looked very, very much like they were going to occur starting last March, a year ago, but they did not. Although just recently, in the last couple of days, President Biden is talking about new tax changes. So we may be starting the cycle of concern again about what could be coming down the pike as far as tax changes. But right now, we are living in a wonderful environment where we have advantageous capital gains laws. We have a $5 million Maryland state estate tax exemption. So these are just a very, very powerful set of tools for you to do your estate planning with not so much worry for most people, not all, for most people that they can avoid estate tax and don't have that worry. That allows us to focus on other things, such as customizing the estate plan for other concerns or goals, or asset protection and other types of concerns. Now, the portability, and this is for someone who is married, I apologize to those of you who are not married, the use of your spouse's exemption amount should they pass away. The portability laws have not been changed since 2021. They continue to be very advantageous. If you are a surviving spouse, you have 24 months to elect to use the exemption amount of your deceased spouse. This is called the portability of the deceased spouse's unused exemption amount. The DSU, the deceased spouse's unused exemption amount, that acronym. So this is something that it just makes estate planning extremely simple, tax planning extremely simple, and very powerful. Between spouses, if you're married, you can plan for control upon the death of one of you or no control, and you can plan for marriage protection. Maryland has new laws that protect spouses, and so if we're not careful, we could have all the best intentions in the world, but if we remarry without the proper protection, we could lose a third of our estate to our new spouse instead of that third going to our family members. So these are the kinds of things that we want to keep in mind. We have some wonderful advantageous laws, but we have some wonderful estate tax and income tax planning environment that we still have, but we also want to keep in mind all of the other things that are a concern that have nothing to do with taxes and nothing to do with some of the traditional concerns. It gives us the ability to think about different things. So it's a great time to be planning, not just because of all of the concerns that we have in the world about getting our planning in place, getting our planning updated, getting our planning, getting an understanding of our planning because of COVID and because of all of the other concerns we have. But the general tax environment is very good, and hopefully will remain so. Now, I'm going to switch gears into the elder law discussion for a while. So many people will say, Steve, what is the difference between estate planning and elder care planning? What is the difference? Well, my opinion is that estate planning has those traditional concerns. How do I leave my assets? How do I avoid taxes? How do I, leave things in the manner that I want to dispose them and accomplish my goals? Whereas elder law takes a different turn. It has the same types of concerns, but not so much, not all. It does have some tax considerations, but it does take a turn into the long-term care aspect, disability, housing, social security, Medicaid planning, asset preservation. So this is the difference between estate planning and elder law planning. And those are just some of the differences. Many times a single person or a couple will be doing what I would call conventional estate planning. They have the traditional concerns about estate planning. And that discussion will take a turn where now we have this juxtaposition, or the two types of planning are now coming together. There's a divergence between the traditional planning, and now it melds into elder care concerns. So again, everything is goal driven. We here at Elville and Associates have the bandwidth, so to speak, or the capability of discussing those two types of planning and how they fit together at times, how they need to converge at times. Now, asset preservation is a big concern for people about long-term care. If you have long-term care insurance or some kind of hybrid product or some kind of insurance product that has a long-term care rider, you are really doing the right thing. And there are some exceptions to that, but generally speaking, you've done a wonderful thing, because that's going to help you preserve assets. If we look at the 3 or 4 major considerations in estate planning, one of the big gaps, one of the big holes in estate planning is long-term care. If we don't have that. Now, if you don't have long-term care insurance or a hybrid policy or some kind of a strategy for that, we strongly recommend that you meet with your financial advisor or other advisors to try to work that out. But there are other strategies available if you are not fortunate enough to have long-term care insurance. When we are talking about asset preservation, when we're talking about disability, when we're talking about all of the elder care concerns, generally speaking, we want to build in lots of flexibility. You may recall when I was talking about the powers of attorney, I was leading you through a discussion about not only what happens if I lose my capability to take care of myself, who is going to pay my bills, who's going to take care of my spouse, who is going to take care of my children or others who are dependent on me. That's the immediate concern. But the broader concern is, how much flexibility have I built in? When I start to think about aging and I think about my elder care in the future, have I built in enough flexibility that my goals can be accomplished? Because remember, at that time, you are not able to make your own decisions necessarily. And so have I built enough flexibility into my planning so that my elder care planning and my goals and my strategy to save some of my assets, if that's what my goal is, or no, I don't want to be able to provide that kind of power. I want the assets to be preserved for myself and not divested. And that leads us to the next bullet point, where we can divest assets as we get older. There are ways of doing that under the current laws that allow us to have our cake and eat it too, to be able to hopefully preserve assets without the loss of control, of total loss of control. There are Medicaid strategies, there are veterans benefit strategies, and this kind of planning has to be well discussed, and it absolutely must be goal driven, because it does involve the divestment of assets away from you. If we are going to preserve assets for long-term care, it must involve some type of divestment. This is what it usually involves, and we have to get our minds around that. So as we start to wrap up, and Jeff, we're not close to the end, but we're starting towards the last segments of the presentation. I want to thank everyone again for your time and attention as we now launch into some of the latter topics of the presentation, asset protection. One of the things that has come about since we've had so many advantageous tax laws and such huge exemption amounts that really cause about 98% of people in this country to not have to worry about estate tax is the ability to think about bigger things, to think about other things other than just a tax-driven estate plan. And so we can talk about lifetime asset protection, long-term care asset protection, and asset protection at death as three separate categories of asset protection so we can get our minds around this subject. So let's start with lifetime asset protection. This is something that is not usually thought about as far as elder care planning is concerned. But generally speaking, this is very important for all people who are doing any form of estate planning, is to understand what is protected and what is not. Now, for those of you who are single on this webinar this morning, I again apologize that many of these asset protection strategies are applicable, or basically the foundations, I should say, not strategies, are really geared around people who are married. So I apologize if you are single. Some of these will apply to you and some will not. Tenants by the entireties. This is the joint form of ownership for spouses. This is something that is huge in Maryland. It is huge in Delaware. And this is something that we want to understand. If we own a piece of real estate, our primary residence, let's say, or another parcel of real estate as tenants by the entireties, if we're married, and if we own another asset, such as a brokerage account, as tenants by the entireties, we have a basic form of asset protection. If one of us gets sued, then that whole, that 100% whole cannot be torn in half. It is an undividable whole. So that's kind of a premise of asset protection. And in Maryland and in Delaware, but in Maryland especially, if we own property as tenants by the entireties prior to transferring property into a revocable trust, we are going to maintain our tenants by the entireties protection, thanks to a law about 10 years ago that allows that to happen. So if we own property as spouses and we end up transferring that property into a revocable trust, we will maintain our tenants by the entireties protection. So that's an important principle. Life insurance. Life insurance is protected from the claims of creditors if your spouse or child is the beneficiary. So that's an important concept. Annuities, the same concept. Qualified plans, 401ks, 403bs, 457 plans, for example. Qualified plans are protected from the claims of creditors because it's a qualified plan, that's it. IRAs are protected from creditors. There are arguments about whether IRAs are protected above $1 million in bankruptcy, but basically we can assume that IRAs are protected. Our IRAs are 401ks, but when we pass away and we leave an inherited IRA to our loved ones, we have to understand that the inherited IRA does not have asset protection, according to the Supreme Court about 10 or 12 years ago, ruled on this, that inherited IRAs that we leave children, grandchildren, and others do not have asset protection. We can protect those assets by leaving them in further trusts, but they do not have asset protection. We must assume they do not if we leave a straight IRA to a child or another beneficiary as an inherited IRA. Domestic asset protection trusts, which cannot be established in Maryland, but could be established in Delaware, Alaska, South Dakota, Wyoming, Nevada, and those types of states, maybe about 16 to 19 different states in the United States are domestic asset protection states where you can create a trust that can provide asset protection. Now I'm going to switch gears to the Medicaid or the elder care type of asset preservation. We spent a few minutes there talking about lifetime asset protection, what we can just assume that we have or know that we have just in our daily lives, depending on the status of the asset and our marital status. So in elder care or elder law, we now switch to using Medicaid trusts, for example, as a powerful tool. Or if you're a veteran of a certain periods of war, there are 4 major periods of war, we could possibly use a Veterans Asset Protection Trust as a powerful tool. Now, Medicaid Asset Protection Trusts, or what we call MAPS, M-A-P-T-S, is a creation of the elder law community across the United States since about the early 2000s. And this is a hybrid type of trust, and I like to call this trust the Swiss Army knife of elder care planning. This is a very powerful tool, and in many circumstances can rank right up there with a revocable living trust as really a consideration. So this is a trust that allows a person to divest their assets, but also maintain a certain amount of protection and a certain amount of control is what I meant to say. And the assets are protected that are transferred to the trust. They are protected from the beneficiary's creditors. If the beneficiary were to be sued or a divorce were to occur in the lives of one of the beneficiaries, and it does not give up the cost basis adjustment at death. So the way this trust is designed is it has all of those positive features which we are allowed to accomplish under the current law. And it also starts the 5-year period, the 60-month period for Medicaid, the look period, the look forward period. Many of you have heard of this referred to as the look back period, but this is what we would call in elder law the look forward period. So again, this is a very understated, very powerful tool that oftentimes takes second place to the revocable trust. But in elder care, this is the Swiss Army knife. This is the thing that can get us from point A to point B if we have as a goal asset preservation. So in many cases, we create a revocable living trust and a Medicaid asset protection trust, and that is sometimes the structure. The Veterans Asset Protection Trust can help the veteran be able to divest assets, and through the specific rules that the VA has about some pensions that they have, in particular the aid and attendance benefit pension, this can be a valuable and maybe smart tool to use for veterans asset protection, similar to the Medicaid trust, but different. Many of you know someone who is married and has a spouse who is impaired. They have, unfortunately, an illness such as Parkinson's disease or some other type of long-term illness, Alzheimer's. And what can happen in elder law is we can divest that spouse under the right circumstances. We can divest that spouse of assets. This is where flexibility comes in. This is where the design of powers of attorney come in. This is where staying out of the guardianship court comes in so that we have flexibility. And this can allow a spousal unit to put the assets in the name of the well spouse, but also do some Medicaid planning just in case that well spouse were to die first. Maryland passed the new spousal elective share law that actually has some ramifications for elder care planning, because there was a compromise that said if the spouse who dies first, that well spouse, and that's an unusual circumstance where the well spouse dies first, but it does happen. If that well spouse leaves at least a certain amount of money into a special needs trust, a trust under the will for the surviving ill spouse, if they leave at least a certain minimal amount, then the state of Maryland will have no recovery against that trust. So this is an asset preservation strategy for many couples who are dealing with this unfortunate circumstance. And that's what I'm calling here in the next bullet point, the augmented estate. So this new spousal elective share law has big ramifications for marriage and remarriage. That's part of regular estate planning, but it also has big ramifications for elder law and the strategies that can be used that Maryland has sanctioned and basically put its blessing on. So we're living in a very advantageous time for disability planning for spouses who are ill and are impaired. Crisis planning. Some people want to use a Medicaid trust, going back to that again. to start the 5-year period. This is the 60-month look period. If we transfer assets away from ourselves, we can use a life estate deed to do that, but it's a very simple tool versus a more complex tool that gives us more flexibility, and that is the Medicaid Asset Protection Trust. We can start the 5-year period, and there are strategies to get that 60 months started, and there's flexibility in that 60 months because remember, we want to get that 60 months started, and we want to be able to get through the 60 months without having to stop the plan or having to undo the plan. Now, let's say there's someone who is a single person. We can use something called the Rule of Habs. This is still allowed under the current law. And the basic strategy is that if I am a single person and I have X amount of dollars, and I have those dollars and I need long-term care in a skilled nursing home, I can save about 50% of the remaining assets. So if I have the right flexibility, if my agents and family members, my fiduciaries, are knowledgeable, they're getting the right advice, we can get my care paid for by Medicaid if that's our goal, and we can preserve roughly 50% of the assets. So with regard to asset protection in Medicaid, I would break it down into 3 major categories. If you are married and you need to do a Medicaid spend down, if you've never heard of that, a Medicaid spousal spend down because your spouse is in a nursing home. Through the right strategies and through a little bit of luck, but not so much, we can save almost 100% of the assets. It's on a case-by-case basis. With a 60-month look period, meaning the use of a Medicaid trust to gift assets and still maintain a certain amount of minimum control over those assets and protection over those assets, if we can get through the 60-month period without applying for Medicaid, in Maryland that's called medical assistance, we can save 100% of the assets that we're trying to save. With a Rule of Habs strategy, if we've done no advanced planning, we have never given away assets, and yet we are in a crisis situation. We have the flexibility because we've done good power of attorney planning, good basic incapacity planning, but now we are in a crisis situation. Now we know we can save up to 50% of the remaining assets, even if we had no advanced planning, no divestment of assets in the prior years, but we've got at least the flexibility to be able to utilize the strategies that are available. And one of the last things we're going to talk about today is asset protection at death. So we've talked about asset protection during life, asset protection for Medicaid or elder care purposes, and now this aspect of asset protection, which as strange as it may sound, is one of the easier things to do. So let's pretend that we have passed away and we want to provide a trust for a spouse. Well, we can provide a spousal trust. Many times these are called marital trusts or non-marital trusts, such as a bypass trust or a family trust. These trusts can be spendthrift protected. They can be protected from the claims of creditors, the claims of bad spouses. The question we ask ourselves is, as we structure this, who are the trustees? Is my surviving spouse the trustee? Is my surviving spouse and our children the co-trustees? Or is an independent person or a corporation like a bank or trust company the trustees? We can leave trusts for children and grandchildren and nieces and nephews. We can protect them from themselves, from any weaknesses or other problems they have. We can also protect them from bankruptcy and the claims of bad spouses, bad marriages, and so forth, car accidents, contract deals that go bad. We can protect them in the further trust. Now, the beneficiary can be given a certain amount of control, and that's going to be a question of, again, what is our goal? What are we trying to accomplish? There are pros and cons of this. Sometimes it's a great idea to give the beneficiary control. Sometimes it is not. And many times it's much better to not have the beneficiary in control of their own assets for asset protection purposes. So this is a discussion. It's a design discussion. It is a time to think discussion about what you want and what you're trying to accomplish. We talked about structuring trustees. Trustees can be interested persons like the beneficiary themselves or a relative, or a trustee can be an independent person. So we have some webinars on trustee selection. Jeff is happy to provide that link to you if you're interested. Trust protectors are very important flexibility tools that Maryland has recognized since 2014. Maryland actually calls this the trust advisor, but nationally they've been known as the trust protector. This can give flexibility. It can give special fiduciary powers to a third person, an independent person who is really sanctioned and appointed by you, the person who grants the trust or the will. And this is the person who can direct the trustee to do certain things. This is the person who can amend the trust if the laws change. And of course, special needs beneficiaries have special, truly special and significant needs. We are very, very blessed here at Elville and Associates to be a part of the special needs community, and we take that very solemnly and seriously. And there are very significant unique considerations for protecting special needs beneficiaries and how those trusts are structured. And there are several types of special needs trusts that are beyond the scope of today's discussion. The SECURE Act was set up, I should say, or implemented in January 1st, 2020. There are new regulations that have just come out. We're getting our mind around those regulations. This affects most estate plans, but not all. And it ends the ability for a healthy person to stretch out or be able to tax defer an IRA for their lifetime, for their life expectancy. So there are some exceptions to the SECURE Act. Chronically ill individuals, special needs or disabled individuals and their special needs trusts, spouses, people who are less than 10 years younger than the plan participant, and minors, children who are less than 18 years old. So those people are exempt from the SECURE Act, and they can still stretch out IRAs according to the life tables, but others cannot. So we are in the process of reviewing the regulations, which finally came out, and all estate plans need to be reviewed. There are strategies for dealing with the taxation, the acceleration of taxation for healthy beneficiaries. Many of you are saving a lot of assets in retirement plans. This is going to affect those. There are strategies for life insurance to turbocharge your estate plan because of the loss of taxes that your beneficiaries may suffer, if that's a goal of yours. Roth conversions, charitable strategies, and other strategies that can be discussed. So we just need to be aware of the SECURE Act and its ramifications. Elville and Associates has a client care program. What we have this for is for the encouragement of our clients to remain in partnership with us, but mainly to update their planning. So we want to not only talk about updating, we not only want to talk about perfection in estate planning and the uphill climb that we have to take, but we want to facilitate a way for you to do that, for clients to be able to do that. So we are one of the only law firms in Maryland that has a client care program. We're very proud of that, and we're happy to talk to you about that. I'm not going to go through the details of it, but this is essential to you and your children and family members for education, and really just being consistent throughout the years to encourage you and your family members to continue to update your estate plan. Now, as we wrap up, I want to leave some time for questions. We're on time. We want to suggest a path forward for you. So we're here to help. We're here to provide information. We're here to educate, but we also want to give you a consultation. We don't charge for estate planning consultations. We want to encourage you that there is nothing to fear. This is a very strange phenomena for many people to, especially in this day and time, to come talk to someone they've never met before, perhaps, to talk about very personal things. But we have complete confidentiality in our conference room here. We have privacy. We have the latest tools. We have 3 major conference rooms here at Elville and Associates. We encourage you to come with your estate planning documents. Bring what you currently have. Let us review it. We do not charge to review most documents. We want you to complete an estate planning questionnaire, because without a proper questionnaire, we can't really know about you and know what your goals are and what your assets are and know what your general family looks like. We want you to consider having an advisory team. If you have a financial advisor now and a CPA, we want to know who they are. We want to hopefully eventually meet them and collaborate with them. We want you to come with questions. We want you to take the time to type up or draft up your questions, things that are on your mind, things that are concerning to you, things that you want to talk about deciding this last bullet point here. What are my goals? If I haven't fully developed those goals, I want to talk about it. I want to talk about my concerns and see what are the strategies, what are the recommendations and advice about moving forward. Basically, we want to make sure that you have the time to think. All right, well, I just want to thank you again for your time and attention. Jeff is going to wrap up our discussion today, see if there's any questions. Feel free to email me at steve@elvilleassociates.com or Jeff, my good friend and colleague Jeff, Jeff@elvilleassociates.com. Jeff is not an attorney, but he is our community relations director. And my personal assistant is Mary Gay Kramer, who many of you may be familiar with. Mary is a very well-known person. Her address is mary@elvilleassociates.com. Jeff, I'm going to turn it over to you, and thank you everyone for taking part of your morning here this morning with us, spending it with us.
Well, thanks, Steve. Fine presentation as always. And before I wrap up, we do have some questions that have come through over the past several minutes. And so now would be your time to get your final questions in for Steve. And I'm going to go ahead and go through those right now. Second here, excuse me. So the first question we have here is, we have a comment from Joe Sperling, our good friend at Joe Sperling Insurance. As you were mentioning long-term care insurance a few minutes before, he typed in, the importance of long-term care insurance coverage, I should say, cannot be overlooked or overemphasized. It's vital to protecting a retirement plan and preserving assets intended to fund the quote golden years and for bequests to family and charities. So,
thank you, Joe.
Very well said. Next question. Sir, is a Medicaid asset protection trust a revocable or an irrevocable trust?
Thank you for that wonderful question. It's an irrevocable trust, and it has to be irrevocable by its very nature, because what a person is doing, or what you're doing there, is you are showing the world, showing the IRS, showing the world of trust and estates, showing Medicaid agencies and the federal government that you have parted with those assets. You have given away those assets. And what we're doing in that Medicaid trust is giving away those assets. There's no question you are parting with control of those assets, but through tax and Medicaid techniques, you can maintain some strings of control over those assets while giving them away at the same time. So it's a hybrid trust, but it is irrevocable. Thank you.
Okay. Next question. Under what circumstances would a married couple want a bypass trust as opposed to a typical marital trust?
That's a great question as well. Thank you. So I'll just give you a simple answer from my point of view, although there could be many reasons. In a marital trust, let's say a spouse dies and is leaving assets to the marital share. They're leaving assets towards their surviving spouse. In a marital trust, the government says that if the deceased spouse is going to exercise control over the surviving spouse, but they're still taking advantage of something called the unlimited marital deduction, which is very advantageous for estate tax planning, then what they have to do is the surviving spouse must get all income, but they can get principal on a discretionary basis. So they at least must get income, but they can get principal on a discretionary basis. Now, many spouses will say income and principal. but the marital trust cannot be for the benefit of anyone else but the surviving spouse. So that's one issue. The second issue is that you can't require a premarital agreement or prenuptial agreement of your surviving spouse if they get remarried if you use a marital trust, which is called a Q-tip trust. Whereas if you use a bypass trust, you can have someone other than a spouse as beneficiary, such as children. You can also say income and principal or only income. You can design it however you want. But the bypass trust, you can require a premarital agreement, prenuptial agreement. Now, the downside is that if you use a bypass trust because you wanted those extra features, the problem is now you are giving up a cost basis adjustment. So if you use a bypass trust upon your death, the first death of the first spouse, there is a step up in basis. But if the surviving spouse now lives several more years, there is no second step up in basis. You're limited to one. Whereas a marital trust, you get a step up in basis on the first death. And then if the surviving spouse lives a long time after that, you get a second step up in basis as well that will benefit the family. So 2 steps up in basis for the marital trust, only 1 step up in basis for the bypass trust, although you can exercise more control over the bypass trust than a marital trust, generally speaking. That's a brief summary of what I think are the differences between the two.
Very good, thank you. Steve, you're an encyclopedia.
Not so, Jeff.
So next question. If you could please review again leaving assets, IRAs, and non-retirement accounts through a beneficiary designation rather than funding them into a revocable living trust. The primary residence will be placed in a revocable living trust. Also discuss how to leave one child less than others.
Well, thank you for that question. For those questions, a lot going on there that I may not be able to get all of that, but it sounds like you've got a revocable living trust and you're funding that trust at least with real estate. If I were you, unless everything's different for every client, but if it's a general situation where we're just using a revocable trust to avoid probate, I would suggest not using TOD and getting all brokerage accounts and non-retirement accounts into the trust, including tangible personal property, intangible personal property. Use the revocable trust as a funnel. Use it to hold all your non-retirement assets because that's the tool that it is meant for. Now, if you use TOD or something and you say, well, this particular brokerage account or this particular money market account or whatever, that's going to go this particular way by POD or TOD, there's nothing wrong with that as long as we understand why we're doing that. But generally speaking, I would use the revocable trust as a powerful tool to consolidate how everything goes down the line without probate. Now, IRAs and so forth, they can be beneficiary designated to a revocable trust. There are pros and cons of doing that. They can also be beneficiary designated directly to beneficiaries. They can directly be beneficiary designated to sub-trust for the beneficiary. So not the revocable trust itself, but the trust that the trust or trusts that are created under a revocable trust. So there are various pros and cons to doing those things. Sometimes the most efficient thing to do is to leave it directly to the sub-trust for the beneficiaries, if there are trusts for the beneficiaries. So that's a counseling issue. And as far as leaving one amount to one child and not another, that is a case-by-case basis where it's going to be all about family relationships and how you say that, and making sure that you're minimizing disputes among children. We don't want to create a flashpoint at your death for a controversy. So those are things that we would have to talk about in person, but there are nuances about how to do that depending on what the relationships are and what the circumstances are. Thank you.
Thank you. Next question is how do we get the questionnaire? And I can certainly answer that. So typically that's something we would send out once you've set a consultation for you to start working on. However, I'm very happy to include that in the follow-up email that I'll be sending out to everybody by tomorrow morning. So it's also available on our website under forms for your information. So I'll send that out for everybody to take a look at. If you'd like to be working with it, please feel free to reach out to us with any questions. Have some thank yous for a great presentation.
Thank you.
Let's see here. Next question, looks like we have a couple more. Someone called me as you were on page 6 with definitions of estate planning. So can you please help me fill in the blanks? Also, do y'all have any colleagues in Texas that you could recommend that are as good as Elville?
Oh, well, thank you for that nice, kind compliment. We will certainly try to connect you with someone we feel is very high quality in Texas. If you'll just give us your general location and where you are. Thank you. I would define very, very basic definition of estate planning as disposing of your property or giving your property the way you want to the persons or organizations of your choice, at the lowest possible cost. All right, thank you for that.
Thank you. Okay, last question for now. And again, now be your time to get that last question in. Not sure if this is beyond the scope here. What of a spouse in a nursing home in another country? This is New Zealand. Is the asset protection mine are large monetary under Maryland law where I live or New Zealand, assuming both? Spouse has no assets aside from Social Security and is a dual citizen of New Zealand and the United States. Sorry, a bit complicated.
Yes, thank you for that. Very interesting question. So I think, and I'm just going to make a big leap and big assumption that New Zealand has very robust nursing and public benefit programs similar to Australia, which I may be completely wrong about that, but I've heard about the wonderful public benefit system in Australia. And I know this is New Zealand, so perhaps it's a very robust thing. That's going to be completely dependent, I believe, on the laws of New Zealand, because that's where the care is being provided. And it's going to be a question about whether they consider the assets of a spouse who lives in the United States to be an available resource, or whether or not your spouse or relative is receiving those benefits in New Zealand based on just the general public welfare system of that country, which is perhaps very, very robust. So I think that's going to be a question of New Zealand law and how it affects your U.S. assets and their view of the spousal unit. If I'm understanding your question correctly, that this is a spouse. So I think that's going to be a matter of New Zealand law, and we could certainly talk to someone in New Zealand as part of a consultation. And we've had to do that several times, talking to various lawyers in various countries in this day and time today.
Thank you. And last question, will the slides be available for review? I can answer that. So we always send the slides out the day before to everybody that has signed up. If for some reason you didn't get them, I always do include them in my post-webinar follow-up message. So, and they are currently available for download in the section marked handouts on your panel on your screen at this time, if you'd like to print them out at this time as well. So it looks like those are all the questions for now. As I wrap up here in just 1 or 2 moments here, regarding our webinar series coming up on Wednesday, the 6th of April at 10 o'clock, Guardianship and the Alternatives, What Parents, Family Members, and Advisors Need to Know. That's going to be with Steve. We also have a couple of new topics on Tuesday, April 12th. Medicare Basics. We have Mark Trent, who is our featured presenter at our 2017 and 18 client event, coming back to entertain and educate us. He's a funny guy and a wealth of information. That's one that you probably don't want to miss. Also on Tuesday the 12th, so we have a double header that day. We have our wellness series at 1:30 after the dementia diagnosis. So our wellness series has been very popular Ellen Platts and Dr. Michelle Fritsch, two wonderful presenters, a wealth of knowledge. So that's something you probably don't want to miss either. Lastly, I want to mention on Saturday, May 21st, we are thrilled to announce our annual client event is back. And for those of you that haven't been to one of our client events, it is our biggest and best event of the year. This is going to be a fun educational event, and we are just so happy to be back in person at the Ten Oaks Ballroom in Clarksville. We have high-level educational presentations, award-winning food, live music, more door prizes than ever. It's going to be a great morning. So, and because we haven't had it for a couple of years, we are opening up to all of our clients, all of our financial advisors, all of our members of the community that support Elville and Associates, that come to our webinars, what have you. So I'll send you all a link to the invitation that recently got sent out. Would love to see you there. So any questions, you can reach out to me.
Don't forget our featured speaker, Jeff.
Yes, our featured speaker is Dr. Anirban Basu. He is a nationally renowned economist, and he is really entertaining, a tremendous wit, and he is going to offer a tremendous presentation as well. So we are very excited and looking forward to that so very much, and want you to be there to celebrate with us. It's going to be a fun day. So with all that said, as far as wrapping up right now, I'm going to send you the MOLST packet Steve alluded to, the video link. I'll send the slides again, the trustee selection webinar link that we had a couple weeks ago, and a copy of the questionnaire that we send out to our prospective clients. And I think that's going to about do it, unless we have any last questions. Looks like we don't. So Steve, thanks for your time. All of our attendees, thank you for being here today. And thank you for being part of the Elville webinar series. We'll see you again soon.